morning. The first case to come before the court is State of Ohio v. Charles Evans. Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know as I'll be keeping track of the time. The arguments are being recorded, so please stay behind the podium. Introduce yourselves, keep your voices up. You should not use the names of children or minors or victims should that be relevant to your argument. You can refer to those individuals by initials or general terms. The judges have read your briefs and we're ready to proceed when you are, and I would just ask the appellant at this time, would you like to reserve time for rebuttal?
Your Honor, thank you. 5 minutes.
Okay, very well. Then you may proceed when you are ready.
Do you want me to proceed to the podium?
Yes, please.
Good morning, Your Honors. Attorney Eric Hall on behalf of the appellant Charles Evans. Your Honors, this case began on or about November 8th, 2020. The appellant Charles Evans was a passenger in a vehicle. The vehicle was driven by a Vicky Rice. They met in Charleston, West Virginia. Mr. Evans needed a ride to Cleveland, Ohio. Ms. Rice agreed to do that in exchange for, I guess, to have another passenger and for gas. That was her testimony at trial. At the time they were traveling, she was driving 90 miles an hour in the 7-mile zone. She was pulled over by the state trooper. State trooper conducted a roadside investigation. At that time, when investigating or looking into the trunk of the vehicle, there was heroin that was discovered. It was an amount that resulted in Mr. Evans being charged with a felony 1. Case proceeded to trial. Mr. Evans did not testify in that trial. There was no motion to suppress filed either in the case because the vehicle belonged to Vicky Rice, so Mr. Evans did not have any standing to challenge the stop in the case. He did not testify in the trial. The jury came back with a guilty verdict, and he was sentenced to an indefinite sentence of 6 to 9 years with post-release control being mandatory. In this case, Your Honors, I've assigned 2 errors, both dealing with the evidence, one with the sufficiency of the evidence, the other with the weight of the evidence, Your Honor. In this case, the appellant was a passenger in the vehicle. The vehicle did not belong to him, it belonged to Ms. Rice. He was an unwitting passenger in this case. The driver owner, Ms. Rice, was speeding at 90 miles an hour in a 70-mile zone for no apparent reason. Well, I would argue the reason was that she wanted to get off the road as quickly as possible because the heroin was her heroin, and that's why she was speeding, because she wanted to get to her destination and get off the road. That didn't happen.
Of course, the other side of it is if you know you have heroin in the car, you should drive really and obey the speed limit.
Oh, absolutely.
So you don't get pulled over.
Absolutely. You would make sure you obey all traffic laws. You have a car that's good, that has all the lights and license plate, lights working, the signals working, and I always thought maybe you put a couple children in the car too, or a dog, but that's neither here nor there, Your Honor. The appellant denied ownership, and he maintained his innocence throughout this, denied ownership of the heroin. Ms. Rice, even though it was her vehicle, and she was the owner, operator, she wasn't charged with anything. She wasn't charged with constructive possession, so our argument is that it was selective prosecution. What's unusual is that she had Mr. Evans' ID that she hid in her bra. For what reason? I mean, there's no reason for her to do that, but she took it. She said, well, the reason is I don't have a purse or pockets. Well, there's no reason for her to have Mr. Evans' ID at all. So she was trying to hide it. She put it inside of her bra. So obviously she was trying to secrete that so the troopers wouldn't find it. She turned it over. That's also evidence of some guilt in this case on behalf of the driver, the owner of the vehicle, Ms. Rice. Again, I think what happened in this case was the investigation. Once they had Mr. Evans, they figured that 1 is enough, that they didn't bother to go after Ms. Rice in this case, even though she's owner operator. In many cases, everybody in the vehicle, if the drugs are in the trunk of the car, then you can make the argument that both Mr. Evans and Ms. Rice had constructive possession of those drugs. Certainly Ms. Rice, I mean, she could be the one, she could have told Mr. Evans to get out of the car and continue on the way, and she would have had the drugs. Mr. Evans wouldn't have had any contact at all with those.
Well, I guess I'm a little confused, so is your argument that because she wasn't charged, she shouldn't have been charged? Because what I got in your brief was that you thought that you were arguing that it was definitely her drugs, period.
That's correct, Your Honor. Mr. Evans denied ownership of drugs. They were in her car. They were in the trunk of the car. You know, and I know in the case, state's case, they argued that Mr. Evans tried to flee the scene. He was tased twice. He's an African-American, Your Honor. And, you know, this was due to panic, okay? Flight or resistance is not always, in every case, evidence of guilt. I know that's the state's going to make that argument, though. But that's not always the case. He's an African-American. He's pulled over by the state troopers. I know that in the trial, there was never any animus of racial animus raised on the fact that the troopers had targeted the car, Ms. Rice or Mr. Evans, but Mr. Evans certainly was scared at the time. That's based upon his actions. Okay, he tried to flee and hit tased 2 times, which, you know, certainly is an unfortunate situation. That obviously didn't help his case in front of the jury, no doubt about it. But once again, I think that the jury lost its way and really ignoring the fact that the driver of the vehicle really got in this and had no responsibility, no exposure at all, and became a witness for the state when actually she's probably the owner of the drugs in this case, Your Honor. So like I said again, throughout the case, at the stop and throughout, Mr. Evans denied ownership of the heroin. He did not testify in this case, which, you know, in retrospect, probably should have testified and just reiterated what he had maintained from the beginning of the case. The heroin did not belong to him. Thank you. Do you have any questions?
Thank you. You'll have your full 5 minutes for rebuttal.
May it please the court, my name is Stephanie Zuranek, and I'm from the Medina County Prosecutor's Office representing the appellee, the state of Ohio. We're here to argue that there was sufficient evidence to sustain Charles Evans' conviction for possession of heroin, and the conviction was not against the manifest weight of the evidence. First, there was sufficient evidence to sustain his conviction. He was found guilty of 1 count of possession of heroin, a felony of the 1st degree because of a 63.6390 grams of heroin. Revised Code Section 2925.11a states, no person shall knowingly obtain, possess, or use a controlled substance or a controlled substance analog. A person acts knowingly according to Revised Code Section 2901.22b when the person is aware that the person's conduct will probably cause a certain result or will probably be of a certain nature. In this case, Evans knew that the heroin was in his bag. Officer Chambers testified that after Trooper Pangburn opened the trunk of Ms. Rice's car, Evans began to get nervous and asked if he had probable cause to search the trunk. He also attempted to flee before Trooper Pangburn could put handcuffs on him. As appellant stated, the Supreme Court has held, that flight, escape from custody, and resistance to arrest are admissible as evidence of consciousness of guilt and thus of guilt itself. In fact, they had to tase Mr. Evans several times before they could get him to be subdued. After Trooper Pangburn searched the car, Evans reached into the trunk and inside the duffel bag with his name on it and grabbed 1 shoe. He then pulled both shoes out of the trunk and said, it's hers. But Trooper Pangburn had not told him that he had found anything in the car or indeed what he had found in the car. Heroin is a controlled substance according to Revised Code Section 2925.11. Lindsay Tedder from the Drug Chemistry Section of the Ohio State Highway Patrol Crime Lab testified that she tested the substance in the bag found in Mr. Evans' duffel bag, and that it was heroin. Possession is defined in Revised Code Section 2925.01k as having control over a thing or substance, but may not be inferred solely from mere access to the thing or substance through ownership or occupation of the premises upon which the thing or substance is found. Constructive possession is defined by this court as knowingly exercising dominion and control over an object, even though that object may not be within the possessor's immediate physical possession. Evans argues that Ms. Rice, the driver and owner of the car, had constructive possession of the heroin. He also cites the fact that she was speeding, and Ms. Rice actually testified that she was speeding because Evans wanted her to speed and was very insistent on that fact. However, her speeding does not negate the fact that Evans possessed heroin in the car. And here, the jury found that Evans had constructive possession of the heroin. It was in a bag with his name on it, inside a man's sock, inside a man's shoe, and Evans was attempting to reach for the shoe after Trooper Pangburn searched the car. Second, Evans' conviction was not against the manifest weight of the evidence. This court has stated that evaluating evidence and assessing credibility are primarily for the trier of fact. The jury heard testimony from Trooper Pangburn about finding the heroin in Evans' bag and chose to believe that testimony. The jury also heard testimony from Ms. Rice that she did not have men's shoes in her car before Evans got in her car, and that she did not put any drugs in her trunk. Also, she was not even aware that marijuana was in the front of the car as it was on Evans' shirt. Again, the jury chose to believe her testimony.
Did the defendant argue below that this wasn't really Ms. Ryder, the driver's cocaine through heroin to the jury? Did the defendant argue to the jury this wasn't mine, it belonged to the driver?
No, he didn't, Your Honor. There was no testimony from the defendant.
Even argument, if the closing argument, did he argue this wasn't my client, this was obviously the driver's?
I'm not sure, Your Honor.
Okay.
Other questions?
No.
Thank you.
Thank you.
Just briefly, I'm going to reiterate the points that I made, but also, regarding constructive possession, because the vehicle belonged to Ms. Rice, she's the owner, operator, the driver, she could exercise more dominion and control over the heroin than Mr. Evans could. She controls it. It's her car. She can take the car wherever she wants. At some point, if they wanted to make a bathroom stop or something, she could have driven away with the car and left Mr. Evans behind. That obviously would have been near to the benefit.
Was that argued below that this wasn't his drug and it was really belonged to the driver and you should have quit because of that?
Your Honor, I think that's what the inference was. I don't think it was that strongly argued at the trial court level. I think the arguments were basically that Mr. Evans, the drugs weren't his. I don't think the focus was too much on that Ms. Rice owned the drugs. I think a lot of it was just challenging some of her statements, the fact that she was speeding, the fact that she had Mr. Evans' ID in her bra.
Was there any testimony to why she was holding his ID?
She said that Mr. Evans gave it to her and told her to hold this. So, under those circumstances, when you're being stopped by the police, if you haven't done anything wrong, obviously there's no reason for you to take somebody's ID that you barely know and hide it in your underwear.
But on the other hand, why is it some reason to give somebody your ID and ask them to hide it?
That's a good question, Your Honor. I'm not sure what was going through Mr. Evans' mind at the time of the stop because he had testified, but the testimony from the trooper was he appeared to be nervous, and I would attribute that to the fact that he's an African American male, he's pulled over by white Caucasian police officers. Some of the things that people hear on the news, that there's a perception that the situation could turn into a dangerous situation for somebody who's a minority.
But he wasn't pulled over. She was pulled over.
I'm sorry, that's correct, Your Honor. She was pulled over, but once the stop, once the vehicle stopped, the troopers quickly identified who the passengers were. In this case, I think there certainly was some suspicious activity on behalf of Ms. Rice. Speeding, agreeing to take this gentleman from Charleston, West Virginia, that she didn't know, all the way up to Cleveland. It sounds to me like that would be something that would be transporting drugs, and she wanted a passenger with her for that purpose.
And that was all heard by the jury, right? That was presented to the jury.
Your Honor, yes, and the transcript is, it's about 100, it's less than 200-page transcript, so it was a very short trial in the case. And again, you know, there was no opportunity to challenge the stop itself or the search because Mr. Evans wasn't the owner of the car, so he had no standing to do that. But again, I believe in this case the jury lost their way, that there wasn't sufficient evidence to find, in terms of the guilty verdict in this case, and the finding of guilty was against the weight of the evidence, Your Honor. Thank you. And I ask the court to overturn the appellant's conviction in this matter.
Thank you very much. Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision to you on the day that it is released, and it will also be posted on the Ohio Supreme Court website. Thank you again.